Good evening, ladies and gentlemen. Thank you, Mr. Chairman, as ever, for your all too kind and flattering words. I propose just to say something, I hope, in about maybe 10-15 minutes, by way of the historical background to the referendum process, because I know that a lot of people wonder, and wonder perhaps correctly, why it is that we have so many referenda. I think Switzerland is the only country that is ahead of us in the EU, or maybe we are on a par with Italy now, but certainly between ourselves, the Italians and the Swiss, we're way ahead of the other countries. I think France is maybe in fourth place, but at all events we seem to have a lot of referenda. And why is that? Well, I think to understand that, you have to appreciate what was in the minds of the drafters in 1937 and the experience they had had with the referendum, or rather the lack of it, between 1922 and 1937. Because by the time the new Constitution was enacted and voted on in July 1937, and incidentally it was the first Constitution anywhere in the world that was voted on by a public referendum, the Constitution of the Free State was left in as a thing of tatters, really. It had been amended in a most profound way on numerous occasions by the Oireachtas by means of ordinary legislation. And that was at the heart of the problem, that there was really no constraint on the power of the Oireachtas to amend the Constitution, either expressly or, even worse, implicitly. And again, so to understand the background to this, you have to just look in the first instance at Article 50 of the Free State Constitution, which I've reproduced on the first page, the handout. And you'll see that it envisaged that there would be a referendum, but at the last minute, in the Constituent Assembly in 1922, at the time when the Civil War was raging outside, a last-minute amendment was put down allowing for the Constitution to be amended by means of ordinary legislation within an 8-year period. Now, there was a complication because you'll see that the amendment had to be within the terms of the Scheduled Treaty. There wasn't, or it was thought that there wasn't, the capacity to amend the Constitution insofar as it was in conflict with the Anglo-Irish Treaty of 1921, which was annexed to it, for reasons that I think are a separate issue. That guarantee, which is really at the British behest, turned out to be illusory from their perspective, but that's a separate story. But for our purposes, what counts was that while it was envisaged that any amendments to the Constitution would be by means of referendum, that never happened. And it never happened because of a last-minute amendment which allowed, as I say, for the Constitution to be amended by means of ordinary legislation, i.e. an act of the Oireachtas, without having to go to a referendum during the 8-year period. And it's clear from the material from 1922 that it was envisaged that really that this would be a safeguard for largely technical amendments to deal with unforeseen problems that emerge and so on. But it was that drafting flaw which was the origins of the downfall of the Constitution itself. Because very shortly after the Constitution was promulgated and came into force in December 1922, there was an indication that the 8-year period would, as I say, prove the undoing of the Constitution. The first of these cases was a case called Regina Cooney and Clinton, which is only belatedly reported in the Irish reports in 1935. But it was decided, actually, it was the last judgment ever delivered by the Old Irish Court of Appeal. And the Old Irish Court of Appeal was one of the transitory courts, really carry over from the previous pre-22 regime, and it was carried over until the new Supreme Court could be established, which took place in June 1924. So I think actually the last judgment of the old Irish Court of Appeal before the Supreme Court was established, in Cooney's case, the Court of Appeal indicated that they could not see how legislation could be challenged as unconstitutional during the 8-year period, because they said that if there was a conflict between an act of the Oireachtas and the Constitution, even though the Act of the Oireachtas didn't intend expressly to amend the Constitution stood pro tanto amended by this Act. And this came to be known as the implicit amendment doctrine, that not only could you expressly amend the Constitution by an Act of the Oireachtas, so, for example, saying we're going to delete Article 5 or Article 6.1 or whatever, but it could also be done implicitly. So an Act of the Oireachtas which happened to be in conflict with the Constitution, according to the Court of Appeal, automatically amended the Constitution, even though nobody ever foresaw, knew, anticipated that, or anybody could say if it did amend the Constitution, how it amended the Constitution, or which provisions of the Constitution were so amended. So that was a very debilitating doctrine to start with. And if you were going to design a Constitution, to find that within a year and a half, a hole had been blown in the whole project by one might say, rather curmudgeonly judges in the Court of Appeal, whose way of life was now to go the way of all flesh, that this was their parting shot. If you're cynical, you might have thought there was something in that. But in any event, Cooney's case blew a hole very early in the Free State Constitution. And that was continued. And in fact, the Oireachtas, I suppose, added to the difficulties because after the death, after the assassination, murder of Kevin O'Higgins in July 1927, the Oireachtas passed the Public Safety Act, which allowed essentially for executive detention of suspects for a long period of time. And Section 3 of that Act said, insofar as this Act is in conflict with the Constitution is amended. And in addition, this was expressed to be for a temporary period of time, that this legislation lasted for a 3-month period. So you could have for a period of 3 months, the Constitution was amended apparently, if there was a conflict, by a piece of temporary legislation for a 3-month period, and again without the legislation saying what provisions, if any, of the Constitution were amended. So that posed a huge difficulty. Now, in a case, Attorney General MacBride, where later famous statesman and politician Sean MacBride was arrested under this section, and the question arose as to whether this was a valid amendment of the Constitution. Mr. Justice Hanna in the High Court, with, I think, a great deal of reluctance and a lot of criticism of the technique, felt compelled to hold that it was a valid amendment. And again, you can see how unsatisfactory this was, that the Constitution could be amended obliquely, indirectly, without specifying what amendments were going to be made to it and so forth, and even for a temporary period of time. Now, worse was to befall the Constitution, because in 1929, a year before the 8-year period expired, the Oireachtas passed the Constitution Amendment Number 16 Act 1929, and that gives you its own indication. They had already 16 amendments in a 7-year period, and that extended the 8-year period for another 8 years. And that meant that if this was a valid amendment, there was really no limits to what the Oireachtas could or couldn't do with the Constitution, leaving aside the special case of the treaty, which was solved in a different way. But so far as the non-treaty material is concerned, 95% of the Constitution, it could be amended. There was it had really no restrictions or restraint on the Oireachtas at all. And this the validity of this was upheld by the Supreme Court in a case called the State Ryan and Lennon in December 1934. And that really spelt the death knell of the Free State Constitution. It couldn't really legally survive, I think, whatever about political difficulties. From a legal perspective, it was holed below the waterline with the decision in Ryan's case, because, again, a majority of the Supreme Court, very bitter, biting language from both majority and minority, it ought to, the judgments really ought to be in some anthology of prose, really. They're so interesting and at one level vicious even. But the Supreme Court, nonetheless, by a majority, upholds that amendment and says it was valid to extend it from 8 years for another 8 years. So there was no limit. During the lifetime of the Free State, there was no limitations at all. Now, should mention in passing, the drafters were familiar with this problem in another country, on which, in fact, both the 1922 and the 1937 Constitution was substantially based. That's, again, another story. It was the Weimar Constitution, the German Weimar Constitution of 1919. It had the same type of problem. What the Germans, with their fondness for portmanteau words, with no quite English equivalent, called a Verfassungsdurchbruch, a constitution breakthrough. Now, when we hear the word breakthrough, it's normally in the context of industrial relations. There isn't breakthrough in negotiations, there isn't going to be a strike. But they mean it in a different way. Breakthrough in the sense of you break through a protection or break through a bag and you punch a hole in it. And this was the same problem manifested itself in Weimar because, again, because of a drafting problem, you could indirectly amend the Weimar Constitution. Now, this, just take a minute, if I may, to digress on this. The Weimar Constitution originally had a ban on deficit spending. You could only borrow for capital purposes. That might sound familiar and echoes of a certain lady at the moment, but that was a strong streak in the German tradition. There's only one problem. Germany had to pay for the Versailles reparations, and if it couldn't engage in deficit borrowing, then it had to do it some other way. And the Reichsbank decided that it would engage in what is nowadays called a bit of quantitative easing. But unfortunately, they rather mismanaged the process. And by 1922 and 1923, because the government couldn't borrow for deficit purposes, as I said, they just had to turn on the printing presses, so they did a huge inflation problem, leading to the hyperinflation of 22 and 23. Now, this then gave rise to another difficulty, because the Weimar Constitution said you have to elect your president directly through the people. And it was thought at this time that it would be dangerous to have such an election because they were through this period of crisis with the hyperinflation. So they came up with this idea of the Verfassungsdurchbruch, that you could pass a law which actually was contrary to the Constitution, but since you had the same kind of implicit amendment doctrine as we had in the Free State, it was still valid. And this was called an Ermächtigungsgesetz, an enabling law. And while the people who came up with the first enabling law were well-intentioned, there were certain people waiting in the wings who used this to devastating effect in the 1930s. And hence, so when the Nazis came to power and you had the Reichstag fire and all the rest of it, they then invoked the idea of this Ermächtigungsgesetz, the enabling law, and suspended most of the rest of the Constitution. And it's the same drafting flaw in both Weimar and the Free State. And the drafting committee that Mr. de Valera had established from 1934 onwards, with different personnel and different individuals, again another long story, but the chief individual, John Hearn, legal advisor in the Department of Foreign Affairs, totally familiar with this. And he, in the earliest drafts of the new Constitution, is wrestling with this problem. And he came up with a solution in October 1935 that you would have two possible solutions. One is that the fundamental rights provisions could only be amended by referendum, whereas the rest of the Constitution, the non-fundamental rights provisions, could be amended by ordinary legislation. That was one possibility. The other possibility was the one that was ultimately adopted, which was that you could only amend the Constitution by express language, with the intention to do so and specifying how you were doing so. And that's what you find in Articles 46, 47, and one of the transitory provisions, Article 51. Because Article 46 essentially bans implicit amendments, temporary amendments, and so this is just a little note on the second page, and it says that you can only have an express amendment. It has to be an act entitled an act to amend the Constitution. You have to specify what you're doing, and there's the further protection that the constitutional amendment cannot contain any other proposal. In other words, it can only be, it must be an act or bill introduced in Dáil Éireann in the first instance, containing only a proposal to amend the Constitution that is express and specifies this. And again, interestingly, Article 46.3 finds a parallel in Article 79.1 of the German Basic Law of 1949, because they, of course, had the same problem, destroyed Weimar, and they were determined with their so-called eternity clause in the German Constitution or Basic Law of 1949 not to repeat the same problem. So they came up with the same solution as Hearn did, which was you could only have express amendments. And in
5 or 6 minutes.
Yeah, in fact, I won't take even. Thank you, David. I won't even take. I'll try and finish in a minute. There was one other clause which should be mentioned, which is that Article 51 of the Constitution allowed for a transitional period of 3 years in which you could look at the Constitution and see where there drafting errors and so on. And that 3-year period was to date from the period the first president took office, and President Hyde took office in June 1938. So the 3-year period expired in June 1941. And the transitory provisions of the Constitution, which are not replicated in the now published document, but these transitional provisions allow the Constitution to be amended with the safeguard that the President could demand a referendum if he thought that the proposal went beyond some technical or non-substantial change. With one additional safeguard, that the 3-year period itself could not be amended by ordinary legislation. So once the June 1941 came and went, after that, for good or for ill, the Constitution can only be amended by means of ordinary legislation. And you had two technical or substantially technical amendments, the first and second amendments, one in 1939, allowing for essentially neutrality, and the second was a series of diverse amendments to particular provisions of the Constitution, for the most part largely technical and drafting in nature. But after 1941, you couldn't have any amendment to the Constitution other than by means of a referendum. And while I dare say some people might think that has disadvantages, I'm sure lawyers and political scientists and others might agree or disagree with that, one thing certainly is the case, is that it contributed to the stability and enduring feature of the Constitution. And that was the single biggest change from the 1922 Constitution. The 1922 Constitution never really had a chance, even as it was sort of sailing from the harbour in December 1922. It was very quickly holed below the waterline, and that's why, again, for good or for ill, and again, probably not for me to make any further comment on that, but that's why, in a very different era, in a very different time, the Constitution has endured and survived and, on one view, thrived. And if there's a single reason for that, ladies and gentlemen, I suggest it is the experience which the drafters gained from the what happened to the Irish Free State between 1922 and 1937. And I suppose, in a sense, constitution drafters are a bit like generals always fighting the last war. Well, the last war of 1922-1937 showed what can happen if you don't have this type of protection. And while we survived it, largely unscathed, another country with exactly the same problem, it led to disaster. And it was for those reasons that the drafters were absolutely determined that the drafting mistakes of 22, which were being played out before their eyes in Germany in 1937, would not be repeated. And I think that, ladies and gentlemen, Mr. Chairman, is the key to understanding the way in which Articles 46 and 47 of the Constitution are drafted. Thank you very much.